Assuming that there was a family health insurance plan at the beginning of the case, the court is going to want to make sure that the children are provided with health insurance after the divorce is over, and that will usually fall upon the obligation of the person who had customarily been providing that insurance. The problem has to do with the other spouse, because after a divorce, if it's a family plan, that person is no longer a spouse and therefore cannot be on a family plan. And in that instance, when negotiating a settlement, for example, it has to be considered that this other person is going to lose health insurance benefits. And that can be dealt with through increases in the amounts of spousal support, maybe a shift of the equitable distribution of assets to compensate financially so that the other spouse can afford health insurance on his or her own. Or if the court is left to make the decision, the court may in fact impose a greater burden on the person paying spousal maintenance to make up for the loss of health insurance benefits, and in fact that's one of the factors when the court is considering a maintenance award. However, today people, because of the burden of the cost of health insurance, a lot of times will stay separated instead of divorced. They will actually enter into a separation agreement which settles all issues arising from the marriage the same way a divorce settlement would, but at the end of the day they're still legally married, and therefore the person who is the non-insured party, if you will, can remain on the health insurance plan under the family plan because there's been no divorce. But of course that can't be forever. Eventually people want to move on, so the issue is pretty much just for the moment dealt with in that manner. But eventually it's going to have to be addressed, and that other person is going to have to get their own health insurance somehow.